Well, good afternoon, everyone, and thank you for joining us. My name is Michael Gault, and I'm an eminent domain attorney with Bell, Carrington, Price, and Gregg. On behalf of Lindsay, Carrington, and myself, we are working with Bell, Carrington, and we are happy to invite you here and happy to have you join us here for this virtual town hall for the US 158 Improvement Project or Reedsville Road Improvement Project. If you're here with us, it's because you likely received a letter from our firm that identifies you as a landowner that is impacted by this project. And that's because public records show that you're a landowner that's impacted by this project. Fortunately, at Bell Carrington, we have the benefit of having some software that allows us to upload and see the impacts to your property in real time. And so we've been able to reach out to you directly to let you know that you're impacted. And now we're happy to sit here and spend a few minutes with you, just going over the project in general, what that might look like, and how we may be able to help as a law firm that represents landowners in eminent domain matters. So let's just briefly step back and look at this project. The 158 or Reedsville Road improvements will essentially be a widening project of close to 19 miles of US 158 from 421 to US 220. The DOT in North Carolina currently estimates that there are around 20,000 vehicles that travel this section every day. But traffic studies show that number is set to increase to around 57,000 by 2035. And so naturally, this particular section of roadway was not designed in its infancy to handle that sort of traffic. And because of that, to improve safety and to reduce congestion, this widening project must go forward. Now, perhaps unfortunately for many of you that are landowners that are impacted, your property will also be damaged. So the way that these cases work is that the state, in this case, the DOT in the state of North Carolina, has the right under the theory of what we call eminent domain to take private property if it benefits a public purpose. Well, there's very little argument that the expansion of a roadway is not a public purpose. In fact, it will be deemed a public purpose. And so then the question becomes, what rights do you have as landowners? If the government has the right to take your property, what can you do about it? If the public purpose doctrine is met, like it likely will be in this case, then your next and most important right as a landowner becomes the right to receive what's known as just compensation. And so basically that means that even though the government can take your property for a project like this, they have to fairly and adequately compensate you for what they are taking from you. Now, that doesn't just mean the dirt value. It means the damages to your property, any improvements that may be in the area of acquisition or the new right-of-way, and any other damages to what we call to the remainder of the property that may go unnoticed, may go unmentioned by the DOT. And that's sort of where we come in. I like to tell potential clients and landowners in cases like this that it's important to know that you only get one bite at the apple to maximize just compensation for the impact to your property. For instance, if you are here in 2023 and you look at the plan sheets, a 2D piece of paper, and the representative from the DOT reaches out to you and they tell you that your impacts are A, B, and C, and so for that reason, they're going to offer you X amount of dollars. Well, that's fine. But if you miss something, and if the DOT misses something, and once construction on this phase of the project is complete in 24, 25, 26 going forward, a few years down the road, and you look out the window and notice that the impact on the ground, the actual impact, is far different from what you ever thought it would be by looking at that drawing, it's too late at that point. If you've already settled the case, if you've already reached an agreement and received just compensation, you can't go back for more. And so it's important in the early stages of a project like this, in a case like this, to make sure that you have someone on your side, in your corner, that can help advise you through the process, that knows how eminent domain works, knows how to make sure that we're not missing any impacts to your property, and to make sure that the valuation at the end of the day and the money that you receive truly represents just compensation for you and puts you back in a position that you would have been before this project started. So a couple of other quick things just about our process at Bell Carrington. I can make you a couple of guarantees, which is not super common in the legal world. The first is that our initial consultations are always free of charge and no obligation. We work daily on eminent domain cases within my team, the eminent domain team. And so we have someone standing by ready to speak with you during an initial consultation to determine if you are impacted, and if so, how you're impacted, and then to discuss how we may be able to help you going forward. So don't hesitate to call us. There's no charge there. There's no obligation there. We're happy to speak with you. Even if we get into the call and see that there's not anything that we will be able to help you with, we're happy to at least take that step to let you know and to give you some additional information. The second is that at Bell Carrington, in our eminent domain cases, we do not charge standard attorney's fees. We do not ask for upfront retainers or out-of-pocket fees or costs from our clients. Instead, we operate on what's known as a contingency fee basis. And that essentially means that we operate on a percentage of the recovery that we're able to ultimately get for you, a percentage of the just compensation amount that is ultimately paid by the condemnor, in this case, the NCDOT. Now, that can get a little complicated and it can vary on a parcel by parcel basis. And so I don't want to dive into the weeds too much here, but I can assure you that if you'll reach out to us, we'll be glad to pull up your impact, and I'll be glad to let you know exactly what the percentages look like and how they work in a case, in your particular case, I should say. So, that's even more of an important reason to reach out to us for that original consultation. You will see either in the chat box or in the video description our information, a name, email, and contact number for you to get in touch with me or our team. That information is also included in the letter that this QR code is located in. If you don't have the letter or the QR code, that information should be here. But again, my name is Michael Gault. I'm with Bell Carrington, Price and Gregg, and Lindsay Carrington and I'm the eminent domain practice group leader. We are involved in this project in North Carolina together to help make sure that landowners are protected. And so we'd love the opportunity to speak with you, to learn more about your property, your impact to your property, and how this project might ultimately change that property's value going forward. We are well versed in eminent domain matters, and we invite the opportunity to speak with you and look forward to hopefully working with some of you in the future. So again, thank you for joining us. Feel free to reach out if you have any questions. We look forward to hearing from you. Thank you.